New York is trying to stall the case, which is currently requesting that the Supreme Court take review away from the lower courts and instead decide on New York's new concealed carry law right here and now. So let's talk about this. But real quick before we jump into this video, I want to thank the sponsor of this video, which is Kershaw Knives. Kershaw manufactures close to 1 million knives in their US factory every single year. Kershaw produces a broad range of knives to meet every single person's needs. If you need a $20 Walmart knife or a $200 US made automatic knife, Kershaw has your needs covered. And just recently, Kershaw dropped their new 2023 line, which includes a variety of knives, including a US made OTF automatic knife. Kershaw makes high quality, durable, and aesthetically pleasing knives that I actually use for my EDC every single day. So I highly recommend Kershaw Knives. If you go over to the website right now and use the code 20scholar, you can get 20% off of your order and free shipping on orders of $100 or more. So head on over to Kershaw Knives, use that code, and thank you again to Kershaw for sponsoring this video. So as I mentioned in the intro, in this video, we will be discussing a case which is currently asking for the Supreme Court to take review powers away from the lower courts and instead to review New York's new Concealed Carry Improvement Act right here and now on their own. The case we will be talking about in this video is called Gazzola v. Hochul. This case involves a challenge to the state of New York's new CCIA law, which was passed in direct defiance to the Supreme Court's recent decision in New York State Rifle and Pistol Association versus Bruen. The Gazzola case is different from some of the other challenges that we've talked about because this case focuses on the impact that the CCIA will in fact have on dealers and gun stores. The businesses argue that they are a critical component to the right to keep and bear arms, and that the CCIA attempts to regulate them out of existence. And because of the CCIA, the petitioner here, the plaintiffs here, are seeking a writ of cert before judgment. And currently, the state of New York is trying to stall for even more time and is asking for the Supreme Court to stall the case out for an additional 30 days, but they put forward absolutely no rationale for why there needs to be an extension of time. This whole case is the result of the Supreme Court's recent decision in Bruen. In Bruen, the Supreme Court struck down New York's may-issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. One of the primary findings of Bruen in that decision was that the government bears the burden to prove that their restrictions are based in the history and tradition of our nation. However, despite that decision, the state of New York rushed through something called the Concealed Carry Improvement Act, or the CCIA, which made the permit scheme in the state of New York even worse than the one that existed prior to Bruen. And it also has a major impact on gun stores and gun dealers within the state. The plaintiffs in this case filed their original lawsuit on November 1st of 2022 in a Northern District Court in New York. In the lawsuit, they argued that the CCIA violated various constitutional rights, including the 2nd, 5th, and 14th Amendment, along also with violating federal preemption. In the case, the plaintiffs sought to obtain a temporary restraining order and also a preliminary injunction from the district court. However, that district court rapidly denied both the TRO and the request for a preliminary injunction in the same order. In fact, the preliminary injunction was denied without even a hearing taking place, and then the plaintiffs decided to submit an interlocutory appeal up to the Second Circuit. The plaintiffs sought for the Second Circuit to find that denial of the TRO and the preliminary injunction to be in error. However, a 3-judge panel at the Second Circuit level, in reviewing that interlocutory appeal, said that the lower court did in fact weigh the applicable factors, and the Second Circuit found that the district court did not create an error. That then led for the plaintiffs here, the petitioners here, to file an emergency application up to the Supreme Court and for them to seek for the Supreme Court to stay the decision of the lower court. That emergency application was originally filed to Sonia Sotomayor, who then referred the emergency application to the full court for a vote. Recently, we received the order from the full court, and in fact, the Supreme Court had denied that emergency application. However, something else had developed in this case while that emergency application was pending. Instead of waiting on the emergency application, the plaintiffs here submitted a petition for a writ of cert before judgment. This is a completely different mechanism, and it's also very rare. This type of petition invokes the Supreme Court's statutory power to grant cert to review a case before the lower federal courts actually hear the appeals or review the case. This type of relief is rare, but has been much more popular lately. In fact, 14 times since 2019, the Supreme Court has in fact granted these types of petitions. This essentially is a way to bypass the hearings, the rulings of the lower courts, and instead to go directly to the Supreme Court for an actual ruling on the merits of the case. Under Supreme Court Rule 11, the Supreme Court can, any time before judgment, deviate from the normal appellate practice to review matters of such imperative public importance as to justify immediate determination in this court. And that is what the plaintiffs here in Gazzola are actually seeking. They want to bypass the lower court's hearings, to bypass the ruling of the lower courts, and instead to go directly to the Supreme Court for them to review the New York CCIA law and the impact that it is having on gun dealers within the state. In the petition, they argue that this case is the organic progression of the trilogy of Heller, McDonald, and Bruen. The FFL in the lawful stream of commerce in firearms is inextricably interwoven with the fundamental individual right. Now, originally, the Supreme Court had set for the state of New York to respond to that writ of cert by February 8th, but New York is now requesting that the Supreme Court give them even more time. In the request, New York states, "I write on behalf of respondents to request an extension of time to oppose the petition for a writ of certiorari in this matter. The current deadline is February 8th, 2023, and respondents respectfully seek an extension of 30 days, up to and to including March 10th, 2023, to file an opposition." Of course, the petitioners in this case have opposed that 30-day extension and point out that the state of New York had plenty of time to write an opposition and to go against what this writ of certiorari is actually seeking, and also that they had plenty of attorneys at their disposal to actually write an opposition. The petitioner also points out that the state of New York's request for additional time, in that request, they present no additional rationale or argument for why they need more time. They simply are asking for 30 additional days, which is in fact kind of unusual. Typically, when a state like New York is seeking more time from a court, they will present some type of justification, even if it's a very lame one. I mean, I've seen states put forward arguments like they need more time to get a history professor who is currently teaching and needs to wait essentially for that professor to be on a break because they need that specific professor. I've seen arguments about maternity leave. I've seen arguments about, well, one attorney changed a position and now a new attorney is on there. I've seen a ton of arguments, but here in this extension of time, the state of New York puts forward absolutely no justification. Now, regardless of that, in my opinion, I think the Supreme Court will still grant the extension of time and give them more time to file that opposition. And whether or not the Supreme Court will ultimately grant this case review, in my opinion, I think it's unlikely. Again, this review before judgment is something that is a little bit more rare, so I wouldn't say that there's no chances. However, with the Supreme Court recently denying the emergency application in this case and also in the Antioch CCIA case, I'm leaning more towards that they're simply going to kick this back down, say, no, we're not going to review this. We're not going to grant this type of cert. The lower courts need an opportunity to hear this case. The Supreme Court appears to be giving the lower courts another opportunity to do the right thing, to hear these cases correctly. And in fact, the Second Circuit recently got a stiff warning from the Supreme Court in the Antioch case. And because of that, the Second Circuit had recently consolidated an expedited review of 6 of these CCIA challenges. So because of those types of developments, I doubt the Supreme Court will in fact just step in right here and now, take review away from the lower court on this case and just hear it on their own. Instead, I see them doing the same thing in this case, saying, no, we are going to give the Second Circuit an opportunity, or the lower courts an opportunity, to hear these cases before we actually step in. But if we get any more information, of course, I will let you all know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.